The next few paragraphs talk about legal remedies. So in paragraph 20, there's a recommendation of legal and tax counsel. Understand that your real estate agent is not a lawyer, is not a CPA, and so it's important if you have any questions at all to consult with professionals that can address those questions and concerns. Time is of the essence. We talked about a little bit earlier in terms of the dates and deadlines table and the fact that deadlines will not extend in contracts that I write, at least. And then what happens if the buyer's in default or if the seller's in default? Typically, if the buyer's in default, liquidated damages are applicable, which means that the earnest money is surrendered. And that's basically the exposure that the buyer has. The seller, on the other hand, is going to be held to specific performance. They can't just back out of this contract once they sign it. And that protects the buyer who's spending money and time in terms of their inspections and due diligence, that the buyer can't or the seller can't just find a better offer and move on. So that's a great protection for the buyer. Legal costs and expenses are defined here. The buyer and the seller agree to go to mediation if there are any conflicts. And then paragraph 24 talks about the specifics of what's going to happen in an earnest money dispute and how that will be resolved if the buyer thinks they should get their earnest money back and the seller disagrees. So again, any specific questions on those, a lot of times it's really case by case, but I can certainly answer general questions if you have them.